right, as we listen to defense counsel deliver his closing argument, I do want to bring in our guest for this hour, national trial attorney Michael Jaafar. Michael, thank you so much for joining us. Okay, what are you thinking of defense counsel's closing here?
I think he's doing a masterful job. Before the defense counsel put on his case, and right before he cross-examined the chief witness, Mrs. Bone, I thought that the case was going very badly for his client. Obviously, his client is not in a good place, no matter what. But I thought the case was not going good. And then when he came in and he started slamming her with the allegations of she was behind on her mortgage, she was pregnant with a kid of a man who was in jail, who wasn't supporting her. She was supporting her children, her mom, her sister. She was alone. She was about to be kicked out of the house. And then he brought in and he got her to admit that the defendant, Mr. Mallorik, was financially stable, was solvent, was giving her money, was supporting her. When he did that, he crept doubt into my mind. So my opinion of his closing argument is that he's doing a masterful job, because his job is to make sure that that jury goes back into the box with one overwhelming feeling, and that's doubt. And I think he's doing that.
Yeah, it's funny how he's saying about the investigators, they've cooked up, he's using that, cooked up this idea. And so, yeah, he is definitely, and I wonder what he's writing down on that sheet of paper there. Is he writing reasonable doubt? And then underneath, I can't see what he's writing, but he is doing a good job.
Yes. Yes, he absolutely is.
All right, Michael, thanks. We are going to get in a quick break. Don't go anywhere. You're watching Court TV, your front row seat to justice. All right, let's bring in national trial attorney Michael Jaafar to get some closing thoughts here on defense counsel's closing argument. All right, he's doing this report card. We have Jennifer, we have Greg, means, motive, opportunity. What are you thinking of his strategy?
I think it's masterful. At some point, he was in a closed room with his client, and he talked to his client, and they had to lay out the facts, and they had to lay out the reality. And the reality was the government has a witness who is going to put you as the assailant. We have no choice but to confront it. What's the answer? And then his client would have told him, well, she did it. You know, and his attorney would have told him, we can't just say she had nothing to do with it and don't believe her. We have to break down her credibility. We have to kill her on cross, and we have to go after her hard, and we have to fight for your life. And that's exactly what you see this attorney doing. He's like a robot going through every single point. And he also got a little bit lucky with the whole financial.
Yeah.
If that woman didn't have financial problems, this would be a much more difficult defense.
Yeah, he's really honing in on that. What do you think, Michael, that the state could come back with? You know, when it comes back up, gives its rebuttal. What do you think?
They're going to come back with this. The immunity we gave her did not bring, the government almost always has to bring in witnesses that are suspect and are compromised, right? So if you look in like mob trials, they will take a witness who is also a killer, who is also a criminal, and the immunity they give that person is not really immunity, they'll lower sentences. So hey, instead of doing 20 years, you're going to do 8 years, right? And so those witnesses are more difficult. The state's going to come back here and say, she was not in jail, she had no criminal record, we didn't offer her anything that she didn't already have anyway. You know, she wasn't doing time. We didn't pay her. We didn't put her in witness protection program. We didn't lower her sentence. So we gave her immunity so she can testify and tell the truth, nothing more. And with historically speaking, this is the lowest that governments have to give to what they gave this witness. So they are holding a strong hand, but it's the financial problems that this woman was having that's going to be the biggest burden for the prosecution to overcome, because obviously they have no answer for that.
Exactly, and we'll have to see what they say. All right, Michael, thank you so much for joining us.
Let's bring in our guest for this hour, trial attorney Michael Jaafar, who has been watching all of the closings today with you at Court TV today. Michael, thanks for being with us. So who won the day?
I think the defense attorney won the day. I think Chris Crawford did a masterful job. I think that he, and I say that because before he put on his defense and before he even cross-examined Mrs. Spohn, I believe that the prosecution had a slam dunk case until he started talking, before he even put out his case, when he started cross-examining her and he brought in the financial problems that she was having, the fact that he was stable, he had many kids, and that she had changed her story many times. I felt like he did a masterful job. Again, these cases are not argued or won in a vacuum. the defense attorneys and the prosecutors don't get to have whatever evidence they want. They have to deal with what they're given, right? You give them ingredients and they have to make a dish out of it. And so he was given, he was dealt a hand and he had to play it. And the hand he was dealt was this former girlfriend is saying he did it. And she seems credible. And so he had to do the work to break down her credibility. I believe he has done it. Did he prove beyond a reasonable doubt that his client is innocent? No, he doesn't have to. He proved, though, that there is a doubt that his client did it because the prosecution has to prove beyond a reasonable doubt that he did it. And there's really only one piece of evidence against his client, and that is Ms. phone, to which Ms. Crawford just destroyed credibility and otherwise.
Well, it seemed like his playbook is blaming it on somebody else. And you know what it reminds me of? Well, another trial in Florida that I covered in Tampa, the ice cream man murder trial of Michael Keatley. That was also another retrial situation, and a situation where they were pointing the fingers at everybody else but the ice cream man, and it didn't work.
Yeah, no, I agree. This is exactly one of the many defenses that you have when you're a defense attorney is to blame it on somebody else, or if not blame it on a specific person, say somebody else did it. We've seen many attorneys fail at that. There was a case where a former attorney, you know, said people broke into my house and killed my mom. I didn't kill my mom, but I don't know, you know, I don't know who it was, and he was convicted. So that defense is very, very scary. But in this case, he had no choice but to do that because this woman was actually saying he did it. Right, and I know he did it, and so it was the logical defense, and the only defense that would have made sense. And I think he did a masterful job. You can't do it better than he did it.
Well, you know, I'm going to push back on that because I'm in a lot of courtrooms, Michael, and I know you do a masterful job, but he was receiving a lot of objections from the state with misstatement of evidence and bringing up things that were not in evidence. And then he kind of lost me with the Chicago Tylenol scare from 1984. I didn't quite understand that. So can you explain to me?
I actually would love to explain that. So my first felony trial when I was a young attorney, I was defending a rape trial. There were two defendants. I was representing one, and the other one, there was a conflict of interest. He had to find another attorney. He found a former judge, right? And the former judge obviously was in his 70s. I was in my 20s. So obviously, you know, he had more experience than me at the time. He came in, and the chief witness was the victim, and we had found out that she had did many years for attempted murder, and she was a pathological liar. But we could not introduce it into evidence. And so I was reading the rule book, and I was telling the former judge, hey, we can't introduce this into evidence. He said, young man, here's what we're going to do. We cannot introduce it into evidence, but I'm going to do it anyway. And I'm going to get an objection, but it doesn't matter because at that point, the trier of fact has heard what I wanted them to hear. And when they go into the jury box, they're going to go in there knowing they cannot unhear that she did 15 years for attempted murder. They cannot unhear it. And they're going to have heard it, and they're going to go in there, and then her credibility is going to be destroyed. He did it. He got yelled at. He got admonished by the judge. We ended up getting an acquittal. I obviously can't prove to you that that's why, but that was a chief piece of evidence. So my answer to you is, you're right. But you know, he wanted the jury to say, hey, he wanted to make it personal, give them a visceral representation that, hey, yeah, I would not take that Tylenol bottle, that pill from the Tylenol bottle, and so perhaps I should not convict this man because there might be a chance that he didn't do it. So that's really what he was going at, but he was getting a lot of objections because he was going over the line intentionally.
All right, we're going to have to leave the discussion there, but don't go anywhere. Still with us, trial attorney Michael Jaafar, watching along with you at home. Michael, give this guy a grade. You're a master at your work. How do you think he did?
A+. A+. At the beginning of this, he was talking about the actual trauma that she suffered with one of her ears almost torn off. That doesn't happen with drowning. All he has to do is prove with forensic experts who testified to the actual trauma that this happened to her, and also the evidence of the phone. She didn't use her phone since 11 o'clock the night before. And she's a financial accountant who works from home. It's not conceivable that she drowned. It's not conceivable that she woke up, didn't use her phone. She runs a big business from home, a business that requires her to be in communication, and she did not use her phone one time. She just went, took a bath, drowned, and oh, by the way, she also has the physical harm associated with strangulation and beating. It's also not a good sign that the defendant's counsel sought to have him not fit to stand trial. I've been in that situation. It's never good. They clearly were in conversations with their client, and they realized he's not really understanding them. He's telling them to do things that they can't do that are going to harm him, and then they asked for an expert to analyze whether or not he's fit to stand trial. It's very sad. You're looking at this picture right now. Looks like they could have had a beautiful life together. But in my opinion, he's a villain. He did it. He's sick. And I'm just going based on what the prosecutor has already said. I'm going to reserve my final, opinion for when the defense attorney comes on. But now that their client is forced to stand trial, I'm wondering what the defense is going to be. I don't know if they have any good options here, Matt.
It really seems like the motive of a money pit turned murder plot is really the basis for the state's case here that, again, is from 2018. What challenges does the state face, and the defense for that matter, when we're dealing with a case that's more than 5 years old?
The state really doesn't face many challenges because 5 years old is still 2018 when we have the era of cell phone coverage and movement and knowing things. This is evidence, for example, that would never have been available in the 80s and 90s, even in some of the early 2000s. So I don't know if there's any challenges based on the 5-year-old nature of the case for the prosecution. For the defense, maybe because they're gearing in the area of my client has schizophrenia. Maybe that might be because 5 years is eternity for a person who is dealing with schizophrenia. 2 months is an eternity. So there might be challenges there, but really not much for the prosecution.
And you know what? It was the 911 call, speaking of all the technology that we had in 2018 and to this day, but it was the 911 call that really led investigators to ask more questions. Let's listen to part of that.
The water's like half full. She's submerged partially, but she's also partially not submerged, and one of her legs is kind of sticking up and out a little bit. And it's just extremely awful, and it doesn't look natural. Obviously, she fell or something happened. And I tried to pick her up. I turned the water off. I tried to pick her up. She's stiff.
This is even better, Michael, because you get to see a bit of that other evidence that'll be presented to this jury, we believe. So the 911 call, he's frantic, and then he acts like that. What do you pick up on in that interrogation video?
Those are the signs of schizophrenia, unfortunately. I don't know if the jury or anyone on the jury is well coached on this, or maybe possibly the attorneys will explain it to them. And I don't really know if they would be able to actually, because of the fact that it has to be introduced by the defendant. And I don't know if they would. But what I pick up from it is this is a person who is not in control of himself. Because there's a big difference between how he spoke on the 911 call, and in that video he's explaining away physical trauma. So that does not bode well for the defense, nor does the 911 call. Because the 911 call, if she really drowned, or if she looked like she drowned, let's just say he drowned her himself. He just kept her underwater, right? Sadly. Then at that point it would be a very difficult case. But based on the physical trauma and the way he's talking in that video and the way he talked on the call, I think it's bad.
Michael, thank you so much for your analysis today, and thank you at home for joining us on this Friday.